Hello, my name is Sarah Coderre, and I am an employment, labor, and human rights lawyer at Bow River Law in Calgary, Alberta. Today, I will be addressing the question of what are my rights in a wrongful dismissal? So, the first thing to understand is what a wrongful dismissal is. A wrongful dismissal is a dismissal that occurs where an employer does not have just cause to terminate your employment, and the employer has not provided you with appropriate notice that your employment is ending or appropriate pay in lieu of notice. The concept of a wrongful dismissal comes from the common law. Under the common law, each employee is entitled to receive reasonable notice of termination in the event that their employment ends due to no fault of their own, so without cause. What is reasonable is going to depend on the circumstances of each case. The courts have said that there is no catalog of uh, notice periods that have been set down. So it is not the case that if you're in management, you get 1 month per year of service. It is very much fact dependent and specific to who you are as an employee, meaning the role you held at the company, how old you are, how long you've been with the company for, whether or not you were induced or headhunted to come join this company from another company you may have worked at, whether or not you have any ongoing health issues or disabilities that the company is aware of that may impact your ability to get a job somewhere else, and really any other relevant factors that might impact your ability to get alternate employment somewhere else, such as whether or not we're in the middle of a pandemic or a recession. If an employer terminates an employee without providing them with reasonable notice or pay in lieu of notice, and there's no contract provisions that allow the employer to provide a lesser amount of notice or pay in lieu of notice, then that employee has been wrongfully dismissed. When you have been wrongfully dismissed, you are entitled to receive damages from the employer. Those damages are equivalent to what you would have received if the employer had given you reasonable notice of termination and allowed you to continue to work and receive pay and receive benefits during that reasonable notice period. So, for example, if we are dealing with an employee whose reasonable notice period is 12 months, and at the 6 month mark, so midway through the year, the employer historically has paid out bonuses for performance in the previous year, then as part of the employee's damages for wrongful dismissal, should they be terminated without reasonable notice or pay in lieu of notice, that employee would be entitled to receive not only the salary that they would have earned over that 12-month notice period and the benefits that they would have received over that 12-month notice period, but also the bonus that they would have received for their work in the previous year if they had been working during that 12-month reasonable notice period. Part of a reasonable notice period assessment, in addition to the factors that I've outlined as well, involves not just sort of a hypothetical assessment of how hard it might be for an employee to find work, but also involving real world data. An employee has an obligation to try to mitigate their losses if they have been wrongfully dismissed by looking for alternate employment that's comparable to the job that they used to have. Part of an assessment for reasonable notice then also involves, whether or not the employee was able to go out and find an alternate job within that reasonable notice period. There are some cases in which someone's reasonable notice period might be assessed as being fairly short because of the type of employment that they held and how long they held it for. But in reality, due to market conditions or changes in that industry, it might take that person even longer to find new employment. And the fact that in the real world it took them longer to find new employment is an interesting factor that the courts will take into account when they're considering how long somebody's reasonable notice period has been. So an employee is entitled, of course, to receive those damages, and they have rights to receive those damages and just sue for them. But on the flip side of that, those damages and their entitlement to them is balanced with the employee's obligation to try to look for alternate employment after they've been terminated without cause. If you believe that you've been wrongfully dismissed, it's my strong recommendation that you do seek advice from an employment lawyer. As I've mentioned, the reasonable notice period assessment is very fact specific. There are some firms that have online calculators that you plug some information into, but oftentimes they can't pick up the nuances, such as whether or not you've been induced to leave your long-term previous employment, whether or not there are other factors such as a pandemic or downturn in your industry that might factor into how long it will take you to find comparable alternate employment. Thank you for listening, and I hope you have a great day.